Right here is a great question. And you're really asking two things when it comes down to it. First, how does a company know whether the person on the other side of that contract is actually allowed to sign it? And second, what happens if someone signs a contract without the power to bind their company and now you are relying on that contract? And so, what you're describing here is called the agency law, and it's the standard for when one person can legally act on behalf of a company. And the core idea is this: a company can only act through people. So when a contract is signed, the legal question is not just who signed it because the company signed it, but whether that person had authority to bind the company, and that's agency. And there are two main kinds of agency, and we call them authority. And so first is called actual authority, and that means the company really did authorize this person to sign. The authority might come from an operating agreement, bylaws, a board resolution, from just the person's role, if they're a manager or an officer, and they're allowed to sign contracts in that role. Second, we have apparent authority. And so this is where people get caught off guard a good bit. Apparent authority exists when the company creates the appearance that the person had authority and the other side reasonably relied on that authority and appearance. And so company emails, company title, negotiating the deal, signing on company letterhead, being presented as the decision maker here. Even if the person technically wasn't authorized, the company can still be bound if it made that belief reasonable through their actions. So how do you protect yourself? That's really what we're asking here. And if it's a small agreement, you usually just rely on the title and context. But for a larger contract with a lot of money involved, you do a simple authority check. Ask who has signing authority, ask for a resolution if needed, or include a clause where the company represents that the signer is authorized to bind the company. And that one sentence becomes extremely important if a dispute arises later on. And you'll probably ask, what if someone signs without authority, even though I tried my best to confirm it? And so if there was no actual authority, but there was apparent authority, the company may still be bound to that contract. And if there was neither types of authority, the company is likely not bound, and the person who signed it could be personally exposed for signing something they had no power to sign. And so there's different avenues you can go down, and this is why some business disputes are really not about the contract terms at all. They're just, the first fight is whether there was a valid contract and whether the right person signed it. And so this entire issue lives under agency law, and it comes up far more often than most people expect.